Okay, welcome to the panel on judicial activism in the field of data protection law, a threat to the European regulator. I'm sure the topic overlaps with many of the other panels in this conference, but here the focus is very much on the role of courts and on the proper role of courts. And courts being both the European Court of Justice and national courts. This panel has been convened by Maja Brkan, who's assistant professor in Maastricht University, who is one of the speakers. My name is Bruno Witte. I'm professor of European law also in Maastricht. You may have seen or not that there's a little side street to this building, and it's called Rue de la Constitution. It's a very small street, so it doesn't seem to be very important, much less important than the Rue Royale, which is a very big street here. So that's one of the questions. How important is the Constitution? How important are constitutional rights in these fields? How active should courts be in enforcing those rights as against other public interests? So that's this sort of general theme of this workshop, of this panel. So I'm not going to go on because we have limited time and we have 5 speakers. So each of the speakers will introduce their theme for 10 minutes, after which Orla Lynksey next to me will moderate the discussion, and there will be, of course, time for questions and comments from the floor. So if we're all ready, then I would like to invite our first speaker, Dr. Johannes Eichenhofer of the University of Bielefeld, to make his presentation, which will be on the German case.
Yeah, thank you very much for the kind introduction and the possibility to speak here at this outstanding conference and to contribute something. I have presented actually 15 slides, which I would like to go through with you within the next 8 minutes, so it's going to be kind of tough, but I will try to keep up to time. Yeah, so my contribution will be about the role of the German Constitutional Court, the Bundesverfassungsgericht, and I would like to start with some very brief remarks, general remarks about judicial activism. What is it? What are the typical advantages? What are the disadvantages? Then I would like to go to present something about the German Constitutional Court. What are its powers and what are its kind of techniques to establish judicial activism? And then in the third part, I would like to give you some examples of judicial activism in the field of data protection. So, in general, one can say judicial activism is one part of judicial review, which is usually being contrasted to judicial self-restraint. And both of these attitudes differ in 2 questions. One is the question of discretion. One could say whether judges should be have the right to come up with own political beliefs or own political preferences. And the second one is the question of authority of power. So should judges actually be enabled to decide with quasi-legislative power? And both of these different approaches differ in some fundamental questions. One is the question of whether you can divide law and politics, and whether you can divide legal interpretation and legislation. And of course, both come to different conclusions here, whereas the idea of judicial activism says, no, actually you can't distinguish both of these ideas, like law and politics and legal interpretation and legislation. Judicial self-restraint would tend to say, yes, you can actually divide both of them. So I would like to discuss the pros and the cons of those 2 concepts with you real quick. Well, advocates of judicial activism would say courts are the institutions that actually need to do justice. They are in our constitutional framework, they are the institutions that are authorized to decide cases, so they should actually decide them instead of avoiding them. And that goes with a lot of respect to the Bundesverfassungsgericht. We will come to that later. Now just some cons real quick. Of course, as soon as a judge decides something, and we will see later with of course, the huge power of the ECJ, it's only a little amount of people who set general remarks and make general bindings, which have a huge impact, of course. So one could say it's rather undemocratic or anti-majoritarian, and one can also say it frustrates the principle of separation of powers, since usually judges are requested to solve individual case instead of making general rules. So I just would like to give you some examples what Germany did, and it has a long tradition, judicial activism in Germany. Even you can find some cases in the early 1950s, even though they do not refer to data protection and privacy. Just to give you a brief overview what is said in the German constitution about the role of this constitutional court, one can say that the court has not only the role to, or the position to review laws, but also to reject laws. And I think this is something which not all countries share. I just put up some general tasks of the German Constitutional Court, but I rather would like to skip that in order to keep in time. One could say, if you would ask now, why is it that the German Constitutional Court has so wide powers, you could actually go back to the historical background of the German Constitution and say, there has been, after the Second World War and all the role Germany played, of course, in it, a huge skepticism towards political institutions, and so they wanted to establish a very, very strict court with huge competences, and at the same time, the Constitutional Court declared its will to also control ordinary courts. So now it's the question, how did they do this? How did they actually make judicial activism? And I would just like to come up with some general remarks, and then we go to privacy and data protection examples. One case which is very famous, it's from the 1950s, it's called the Elfes case. Here the court developed actually something which is called a fundamental right of general freedom of action. So it turned out that almost any case you could imagine somehow is protected by constitutional law, and so the jurisdiction of the Bundesverfassungsgericht got actually bigger. A second technique is that they actually made fundamental rights instead of individual right to give it an objective impact, which also increases their jurisdictions, because more plaintiffs can actually go and say that violated the objective impact of these rights. Very similar is the so-called third-party effect, saying that that case actually, that a fundamental right is also binding to third private parties, and of course then an obligation to protect, which means that you that the legislator is obliged to fulfill the obligations out of the Constitution. And the other examples I think I would rather skip here real quick. That is also one specific legal technique the Bundesverfassungsgericht established. It has in its rulings two parts. One is the first and the second part. The first, the Bundesverfassungsgericht tends to set up general standards of interpretation of a legal norm, and in the second part it applies these standards to further cases, and that is actually something which can be criticized because it's almost like a legal a legal interpretation which is very close to legislation, what the Bundesverfassungsgericht does in that field. And now, real quick, for 2 minutes, or let's say 3, some examples for privacy and for judicial activism in the field of privacy and data protection role. In general, there is neither the term privacy nor data protection can be found in the German constitution, so it was upon the courts to actually create those rights. And one can say that the court actually has set up a huge framework out of many, many provisions, and the idea was that it should be a systematic and gapless protection. So the court tended to, whenever a new threat to privacy and data protection came up, to answer with a new fundamental right. One is the right to informational self-determination, which I think is also common to other countries, and that has been developed due to the new threat in the 1980s of automized data procession. A rather new case from 2008, maybe you're familiar with that too, is the so-called IT fundamental right, or right to guarantee of the confidentiality and integrity of informational technology, kind of long name. And that was due to a case of an online searching by criminal investigators, and they were trying to install a spy or hacking software, and the Bundesverfassungsgericht said, well, to these very new threats, there hasn't been any fundamental rights protection so far, so they invented a kind of new fundamental right. Apart from that technique, you can also see that there is a lot of, they created a lot of criteria for proportionality, for example, in the electronic eavesdropping case or in the data retention case. And now, just within the last 2 minutes, I just would like to discuss with you what you think about that. So what should we argue in favor or instead of this technique, and one could say, okay, the advantages is quite clear because only the court were able to provide a protection of privacy and data protection on a constitutional level. So whenever a new law comes up, it has to be comply with these new with these fundamental rights. Another thing is it's kind of a question of efficiency because, of course, courts are kind of reactive. They just react upon the cases they were brought to them by the plaintiffs. So it can be made sure that the problems actually are violent in the real world. They will be solved, but there is nothing but an over-regulative problem. And just, this is the last slide already, to ask about the disadvantages. One could say, okay, we have this problem of undemocracy tendencies in that field as well. But you can also say that data protection is so specialized and such a technical issue that it has always been a kind of a domain of the experts. And maybe it's not actually the best example for a common will of that is one idea. One can also say that when the court sets up general standardization rules, that somehow frustrates the idea of self-determination and privacy, which is very much, something very efficient. So I would say these were just some arguments, and I would try to hand over the microphone now, and thank you for your attention.
Thank you. Thank you very much, Johannes. And so our next speaker is Professor Giovanni Sartor, I think? No, it's you? Okay, change that. Then it's Dr. Gloria González Fuster.
Yes, thank you.
Researcher here at the Free University of Brussels at our host institution. And she will speak about the Spanish case, I think.
Yes, thank you very much. So I've been doing a lot of research on the creation, on the invention of the right to personal data protection in Europe. But I will not talk directly about this today. I will focus on the Spanish case. And I will try to argue two different things. Well, first, I will explain how in Spain we created a fundamental right to the protection of personal data. And we created this right actually with a strong European influence. So it's not that I'm proud to be Spanish, because it's really a European phenomenon that occurred in Spain. And I will also argue that Spain has also made an important contribution to this creation of a European personal right to the protection of personal data. So at least a significant contribution. But first, a few words on how we created our own right to the protection of personal data. We created this right on the basis of this provision of the Spanish Constitution of 1978. If you look at this, this is the article about privacy in general. You will see that there's a mention of the right to privacy, a mention of other rights, such as the right to honor, to own image, to home, to the inviolability of the home, to the confidentiality of communications, and you will not see any reference to the right to the protection of personal data, because it was not there at the time. What we had, it actually says 111, but it's the fourth paragraph. We have a legal mandate, so an imposition on the legislator to regulate the use of computers. This was something that the drafters of the Constitution in '78 thought it was important to have there. It was not something very original. We just looked at our neighbors. Portugal had already included 2 years before a reference to the need to regulate, to control computers for the protection of freedoms and rights of individuals. And at the same time, the same year, France was going to adopt its own Loi Informatique et Liberté. So in Spain, we thought it's important to have a reference to computers in this article, which is 18.4. Now, this article still generated a lot of controversy already in the drafting process. People were not sure what was exactly the purpose of this. Was it to protect privacy in the face of computers? There was a strange reference, so the law should limit the use of computers in order to guarantee the honor and personal family privacy of citizens and the full exercise of their rights. So what does this mean exactly? There was a lot of debate in the doctrine. A lot of the literature was influenced by the very influential German discussions, and there was an important book on the informational self-determination and whether this was an acknowledgement of informational self-determination. The question was solved in a very important judgment of the year 2000, and it's actually a very beautiful judgment that it's really recommended for everybody to read, because it's the first time that the Constitutional Court in Spain says we do have a fundamental right to the protection of personal data. It's recognized in that right that, as I said, it does not really say so. So it was a creation, very proof of judicial activism by the Constitutional Court in Spain. And it was a case actually related to the Spanish data protection law had been adopted, and the ombudsman in Spain thought some of its provisions violated the constitutional guarantees. So it was very important for the Constitutional Court to say, what does the Constitution say about personal data protection? And what the court did, it looked at this fourth paragraph of Article 18, and it also looked at another important constitutional provision that we have, which obliges the court to interpret all fundamental rights in light of international agreements. But it did not just look at international agreements, because it looked at the United Nations guidelines on the computerized data systems. It also looked at the Convention 108, which is about the regulation of automated data processing, but in the same exercise, he said, well, we have to look at international agreements. Let's look at those international agreements ratified by Spain, and let's also look at Directive 95/46, which is not really an international agreement, but it just, in the fervor of this judgment, is sounded correct. So, and they said, well, this directive is about personal data protection, not just automated data, but generally all personal data. And the court also said in November of the year 2000, let's look at Article 8 of the Charter of Fundamental Rights of the European Union. You know that Article 8 of the Charter is about the protection of personal data. This was November of the year 2000, so this charter had just been drafted. The ink was fresh on the paper because it was not even proclaimed by anybody. But the Constitutional Court said, well, this is like the new wisdom that we have on fundamental rights. We have to take this into account, and we have to read this, our Spanish Constitution in light of this right. So actually, the judgment really explains what is the purpose of this right, what is the difference with privacy. It really tells a lot of interesting things that, of course, it marked a bit the climax of this judicial construction of the right. It said that the law that we have in Spain is implementing our Spanish right to the protection of personal data. It also transposes the directive. And then, of course, because it was a very nice, beautiful judgment, the climax of a lot of discussions, things could only get worse, and they did get a little bit more complicated eventually, especially this idea that this article of the Constitution covers also non-automated processing of personal data did not actually always convince everybody. There's I just wanted to mention this judgment, which is about the cases of apostasy. I don't know if you're familiar with those cases. Apostasy is about the baptismal books. So in the Catholic Church, when people are born, generally they are baptized. So they're brought to the church, they put some water on their heads, and normally, well, after everything is well done, somebody takes note in a book about the fact that this person named in this way has just been baptized. In Spain, this was for many years very, very, very common, so almost everybody was baptized. Eventually, these little children just grew up, and some of them said, well, I don't agree with the fact that the church has a book with my name on this book saying that I belong to the Catholic Church because I don't believe in this. And I want the Catholic Church to delete this. And guess what? There's a fundamental right to the protection of personal data that has to be applied, and they have to cancel this. Some of these people went to the Spanish Data Protection Authority, who said, yes, indeed, you have a right, maybe not a right to request the deletion of the data, but at least a right to, you have a right to request this and to have an answer from the Catholic Church. There was a lot of discussion. The courts in Spain initially said, yes, indeed, there's a right. But in this judgment of the Supreme Court, things changed. And actually here the discussion was a rather technical discussion on whether this book, those books about baptismal records are filing systems or they are not, are they structured? And very amazingly to my sense, the Supreme Court said this is not structure because it's just a book that is ordered on the basis of people who get baptized, but it's not ordered alphabetically. Okay, and it's not ordered chronologically on the basis of the date of birth. So this makes that this is not a filing system, so personal data protection does not apply. But more interestingly for us, for the discussion of today, it also said, and remember that the Constitution does not say anything about personal data in general, it's only covering computers, the regulation of computers. So it was a sort of drawback. And while we had this sort of drawback, we were actually looking elsewhere for protection, and we started to look more firmly to Luxembourg for protection. And this is where I have 2 minutes to explain the Spanish contribution to the creation of the European fundamental right to the protection of personal data. I will just mention 2 cases. This is the Promusicae case. This was not a case where the Spanish courts claimed that anything about this Article 8 of the Charter, but it was a reference for a preliminary ruling where the court mentioned the Charter of Fundamental Rights already in the year 2008, so before it became legally binding. It said, well, there are some important rights that you have to take into account about the right to effective remedy, the right to the protection of intellectual property. And Luxembourg said, yes, indeed, let's look at the Charter. And when we look at the Charter, we found also another right, the right to the protection of personal data. It was the first time that Luxembourg acknowledged that, oops, indeed, there is a Charter to fundamental, there's a right to a fundamental right to the protection of personal data in the Charter. So this was, in a way, not an intended consequence of judicial activism in Spain, but there we come to, just in my final minute, to the Google Spain case, where I will argue that here it's really intended. Here it's the first time where Luxembourg is confronted with somebody who asks, could you please interpret this directive, Directive 95/46, in the light of Article 8 of the Charter of Fundamental Rights. And actually it also suggests to the court, in relation to the question of applicable law, if the directive says law is not applicable, could we just forget about this fact and focus on Article 8 of the Charter and say, well, Article 8 does tell us something important. Actually, in the judgment, the court says, does not use Article 8 in this relation, but it uses Article 8 to say that indeed directive implements this right, and indeed this right recognizes a right to be forgotten. So here, I think the Spanish court really gave to Luxembourg a way, a framing of the question that was adopted by the court, and also, as Artemis Rayo Lombarte said yesterday, it also gave to the court the name of the thing, the name of this right that we are discussing so much today. So just to conclude, my question is, what happens then now that we have actually 2 rights in Spain? From the Spanish perspective, we have one right to the protection of personal data in Spain, another in the Charter. We have this Spanish law that at the same time is supposed to implement one and the other. Everything is fine, they are the same, but what happens if somebody argues that they are not the same? What happens if this directive is transformed into a regulation and the Spanish data protection law then is just one entity? So I don't know in the future how this judicial activism can actually manage this situation that we are supposed to protect 2 rights and we are not sure if they are the same or not. Just I leave this as an open question. Thank you very much.
Okay, thank you. Shall I come there to check?
So our next speaker is Professor Giovanni Sartor from the European University in Florence, and he will speak about the Italian case.
Okay. Okay, let me just, while the slides are coming up, say something about the beginnings of the history of Italian law with regard to privacy data protection. Also in Italy, we had a trend similar to that in other countries, so we didn't have anything explicitly in the Constitution, but first at the Court of Cassation and then at the Constitutional Court. We had the affirmation of right to privacy, starting with the Soraya case, like in Germany, so there is an interesting parallel between our countries. And both privacy and identity were, according to the court, were implied by other constitutional provisions, such as those concerning, in particular, dignity and personality. Again, something similar to what happened in other European countries. Let us now move into the recent times. So in Italy, we have quite a strict implementation of the Data Protection Directive. So all processing is unlawful unless explicitly admitted. We have that coverage also for the press and freedom of expression and legal persons. Then we had some relaxations, excluding legal person and in particular with regard to security measures. So in this context, I would say that the Italian court have not been particularly active in the domain of data protection, in particular at the European level. We had a very activist data protection authority, especially when Stefano Rodotà was the head of it for the first 8 years. Then this activism has slowed down to a considerable extent. Anyway, I couldn't find any reference to ECJ from Italian courts on data protection. This term only appears in Italian cases dealing when there is in issues dealing with access to EU documents. So at least maybe that there is some, but I couldn't find anyone. So there are some controversial domains in Italian data protection law, which have raised some issues also relevant to the European law. So one of these domains is controls over workers, but I think I will skip over that. This is also something, kind of problem that I think are shared with other European countries. We had a constitutional case dealing with regional competencies. And here I think that really it was not, it appears to be a privacy case, but it was not really a privacy case. There is we had a very bad constitutional reform in Italy that gave rise to a lot of confusion concerning competencies, state and regional competencies. And so privacy was a bit hijacked into this kind of power struggle between the government and the regions, who has the power to decide on the privacy matter, and regions that did not address privacy were challenged in front of the Constitutional Court for addressing privacy. If they had addressed privacy, they would have been, so they were challenged for not addressing it against the right to privacy. If they had included privacy regulation, they would have been challenged for doing that, violating the state competence. So I think we can skip this as a relevant aspect for us. We had another decision of the Italian Constitutional Court on a matter which is very specific. And it was decided that one article in the one comma in one subsection in the Italian data privacy code was against the Constitution, to the extent that it didn't allow an adopted child to try to contact his birth mother, his biological mother. So the issue was whether the mother could be contacted by the public authority to see whether she had changed her mind and now wanted to get in contact with the child, who had become grown up and wanted to contact her. So this is one of the few decisions that we have. Where we had some activity from Italian judges, not of the constitutional level, but in all other levels of jurisdiction, in all the 3 degrees of Italian judicial authority, is concerning the right to oblivion. And here we have quite divergent approaches, and the issue is to what extent they match what is happening at the European level, in particular after the Google Spain case. So we have a decision of 2005 by the Data Protection Authority, which obliges, in a case which is quite similar to the Google Spain, doesn't go against Google, but it orders the newspaper to move an old piece into a local archive so that the piece is no longer searchable through search engines. Then we have another decision, I think a couple of years later, sorry I forgot to put the year, where instead tribunal ordered a newspaper not just to put a content online, but to make it unsearchable, but to delete completely the place from the internet. In both cases, this was information concerning criminal convictions that had been legally published at the time when the conviction had happened. So the issue is the passage of time. Then we have another decision of the Court of Cassation, which takes another different path, which is also different from what the Court of Justice did. In this case, it was again an issue concerning somebody who was accused and later acquitted. So again, it is similar in a way to the Google Spain case, even though in that case it was proceedings for, if I remember well, bankruptcy, while in this case it concerns a criminal conviction. So the newspaper published the information about the accusation and stored it in a repository accessible online. The data subject asked for the article to be de-indexed, but the court said that there was no obligation to the index, which would affect right to freedom of expression information. And it said instead that there was an obligation for the controller, in this case the newspaper, to keep the data updated and to add a link to the new information providing about the subsequent acquittal of this person who had been convicted. So I think this trend of decision raises some interesting issues in general, but also we would say in connection with the Google Spain. So the focus is not on the search engine, but on the uploader, on the publisher of the information online. And there is this idea of either taking the content out of indexation or integrating it. We have now, just to mention, this is not judicial, but parliamentary activism. We have a new law on defamation that has been now discussed at the Italian Parliament, and it includes, it states that the data subject has the power to request the elimination from websites and search engines of defamatory content and data violating data protection, a power that may be exercised toward the websites and the search engines. There is no involvement again of the speaker, of the author of the communication, and there is quite a big fine. So we may wonder whether this goes in the trend of EU law following the Google Spain, or whether instead you may argue that it violates freedom of expression, which is also in the European Charter. Okay, no, I think I can skip that. Another interesting issue where we had some activism from Italian courts, and again I think a perplexing kind of activism, is the idea of controllership. We had a trend of decisions concerning a case concerning Google content uploaded on YouTube. Basically it was a previous system but doing the same thing, and we had 3 Google executives condemned for illicit data processing by the Tribunal of Milan, acquitted in appeal and confirmed then in cassation. Yeah, thanks. No, I noticed that. But beyond the decision of this case, there are some interesting statements by the Italian Court of Cassation, where it says that Google is no controller of the uploaded personal data, nor, it seems, of the indexing and retrieval. Again, we may wonder how this fits with the Google Spain case. The course says that Google becomes a controller only at the point in time when it has knowledge of the uploaded data and the possibility of removing it. So controllership is not linked to the fact of deciding to process a data set that also includes personal data, but it is linked to the knowledge of the specific personal data that are included in this data set. Again, I think that you may wonder to what extent this fits. Another point where the Italian law, we had some initiatives by the Italian law, concerns immunities of providers and e-commerce. And we have, the Italian law is peculiar, I think similar to the Spanish law in this regard. It establishes full immunity for provider until they receive a removal notice from a competent authority. At least this is how it is understood. It's not so clear that this is the case, but this seems to be the understanding, at least the literal reading of the text. And Italian judges have found various ways to get around this piece of the Italian implementation of the e-commerce directive. And in particular, they've argued that platforms and social networks do not count as host providers in the sense, in the meaning of which this term has in the Italian law that implements the directive. Obviously, again, you may wonder to what extent this is consistent with, for instance, the case where Google was against Louis Vuitton, where instead even links to advertisements were considered to fall within the e-commerce exemption. So obviously it applied also to platforms to which, according to at least this decision of Italian law, it should be excluded. Another point where it is not clear where Italian law is going, and also where European law is going, I think, is whether the e-commerce directive applies or not to data protection. And there is an article, I think Article 1 of the e-commerce directive, which may be understood as excluding data protection from the e-commerce exemptions, e-commerce safe harbor, if you want. But it is not clear to me whether there is this is the interpretation adopted by the ECJ, which does not refers to e-commerce, for instance, in the Google Spain case, maybe on other grounds on which I don't have time to comment now. But this goes against what is written in the new proposed data protection, the proposal of a new data protection regulation. So here is not clear what comes next. And okay, I don't have time, but we had a case which goes exactly in the direction of the ProMusica case, so it seems that here there is a convergence between EU and Italian data protection law. So conclusion, little conflicts between Italian law and EU law, maybe too much alignment, little activism, I would say, in this domain. But there are some conceptual confusions. I don't know to what extent is a different policy with regard to some issues pertaining to internet law and to human rights in the internet, or whether it's just a problem of clarifying some concepts that at this stage are not so clear. So thank you very much for your attention. Sorry if I...
Thank you, Giovanni. You went a little bit beyond the allocated time, but we calculated that. So we now move to Europe, or at least to the European Court of Justice, so the European level, EU level, with the last two speakers. And first of those is Maja Brkan, who's assistant professor at Maastricht University in European law, formerly working at the Court of Justice, who will now introduce the theme of judicial activism at the European Court of Justice. Maja.
Thank you very much, Bruno. Yes, I would first like to make a more general introduction on what I think judicial activism is. And I'm stemming, my presentation will stem from the research question, is there actually something like judicial activism in the field of data protection? So, I will first speak a little bit about separation of powers, principle of institutional balance, how they interrelate, how they relate to the European Union, then a little bit about what I think is judicial activism, then a little bit more general on judicial activism of the EU, and then judicial activism in the field of data protection. And I'm very carefully looking at the watch not to go over time. So the idea of separation of powers stems back already to Aristotle, but was mostly developed and confirmed by Montesquieu in the 18th century with his trias politica, so the division of powers between the legislative, executive, and the judicial branch. And at the time, Montesquieu actually considered that the judges should be passive. They shouldn't be activists. They should be just la bouche qui prononce les paroles de la loi. So just a mouth that pronounces whatever is written already in the law, which means that the law has to be pretty clear and that there is not much space left for the interpretation. In the European Union, the classic doctrine of separation of power doesn't really apply because the institutions have a bit different role than in the classic, for example, on the national level or in the US. So the EU has developed a so-called principle of institutional balance. And the name of this principle says it all, means that the institutions have to be in balance when they act. So if you look at the principle from a legal perspective, this principle is very much linked to the principle of conferral, which means that an institution cannot act beyond its powers. So the Court of Justice cannot act further than whatever is mandated to the court in the treaties, in particular in Article 19 of the Treaty on European Union. This principle can also be seen as a political principle which designs more or designates more the different functioning between different institutions, but I will refer to the principle as a legal principle which was first mentioned in the Meroni case, where the court confirmed that this is a basic and very fundamental principle of the European Union. And now, how does this principle relate to judicial activism? It's actually two different sides of the same coin, we can say, because judicial activism can, to a certain extent, lead to institutional imbalance. Because if the court goes over its powers, goes over whatever is mandated to it, then it means that some other institution is deprived of its powers, if you look very strictly to the principle of conferral. However, I was thinking about what is the relationship between the notions of interpretation, judicial activism, and whenever the courts go really over their powers when they act ultra vires. And I personally think that judicial activism situates itself somewhere in between the interpretation and the ultra vires action, because methodologically it is still interpretation of the law, but it is interpretation of the law that goes beyond text. And you can very strictly, legally speaking, even say this is contra legem, but if it brings a new right, and if from the purpose-based interpretation gives more right to a particular claimant, then it is very difficult to invoke this argument contra legem in order to say the court wasn't right in doing so. So I think this is a gray area between the actual interpretation and ultra vires, where the court would overstep its competences from the point of view of institutional balance, which in my view means it is allowed. It is not necessarily a bad thing if the courts act a little bit more proactively. So we have had several examples of judicial activism in the past, starting in 1963 and 1964 in Van Hend and Los and Costa cases, where the court actually created the principle of primacy and direct effect. A very striking example of judicial activism is the Chernobyl case in 1990, where the court actually changed the treaty and created standing for the European Parliament in annulment actions, and gave Parliament a semi-privileged standing for bringing the actions of annulment. A very interesting case that I'm still intrigued by, and I still don't really understand it, and where I think it is, the interpretation that the court gave is to a certain extent contra legem, is the case Commission versus France in the field of fisheries, where the court actually changed the treaty interpretation from the word or into the word and, meaning that member states could be imposed financial sanction, either lump sum or penalty payment. That's what the text of the treaty says. which was then changed subsequently by the court into lump sum and penalty payment. So member states can get both types of sanctions, which is of course okay from the point of view of the purpose of that provision, but it is not okay from the point of view of the text. And then, of course, the actual protection of fundamental rights in the European Union is something that has been judicially created by cases such as Internationale Handelsgesellschaft. And in the field of data protection, when I did my research, I stemmed from the hypothesis that we would have a lot of judicial activism, precisely because the directive, as we all know, is obsolete. It was adopted before the internet even existing. And if you think about concepts such as processing or which law is applicable on the basis of which criteria, establishment of the controller or location of processing of the person who processes data, then it's quite difficult to apply them for the current setting. And then in the end we will see if this is the case. So the case Pro Musica has been mentioned already. I will not go more in detail into that, but just to mention that this is the case where the court created the right to data protection. And now the question is this actually judicial activism? On one hand, we could obviously say yes, because that was a creation of the right to data protection. On the other hand, we could also claim, no, this was not judicial activism, because data protection is, in a way, a right to privacy, and I know that Orla might object to that, because she just recently wrote an article on that. But globally speaking, you can make this argument. Secondly, the right to data protection was also developed by the European Court of Human Rights, and we know that the Convention of Human Rights and the jurisprudence of the Strasbourg Court is a legal source for the Court of Justice to judge. So that's also another argument in favor of saying this is not so activist, what the court did in Pro Musica. And also, as Gloria already mentioned, this case was decided in 2008, just before the charter became legally binding. There, the charter recognized the right to data protection. So also from this perspective, it's difficult to say that this was really, really activist, but it was probably more interpretation. And then, of course, the famous Google case, which is, according to some commentators, the prime example of judicial activism. And if you type in judicial activism and Google Spain into Google, you get a lot of results, search results. And I would like to address two issues with regard to Google. One issue is the issue of the territorial scope of application and the interpretation that the court gave in this regard. You all know what I'm talking about. The court said that it is possible to apply a law of a certain member state to that controller, to the search engine, if this controller sets up a subsidiary in this member state and if this subsidiary orientates its activity towards that member state. Now, I will leave aside the question whether the orientating of the activity is a logical criteria or not, because it can be a little bit problematic. How do you orientate the activity towards your own territory? But here, regarding those two criteria, I think that the court was quite activist, because neither the criteria of orientating the activity nor the criteria of selling advertising space is something that is enshrined in the actual text of the directive. So we can say that the court did grasp or did try to develop new criteria with regard to the territorial scope of application. The second issue that I would like to address is this famous right to be forgotten, which is in view of the court, although the court doesn't mention right to be forgotten in the actual judgment, but which is in view of the court enshrined in Articles 12b and 14a of the directive. One of them, Article 12, requiring an illegal processing of data. And I'm just really rushing a little bit with this because I'm running out of time, but one issue that I think it's very important to be addressed is the issue of balancing within the framework of the right to be forgotten. And here I think that the court really was activist, because it gave the actual exercise of balancing into the hands of a private party, which I personally call privatization of balancing. And this move that the court did, this is something that in my view is very dangerous, because not only this private party, Google, can decide on the basis of subjective criteria, but also because when it does balancing, if we have a person that plays a role in the public life, then how can Google actually assess which role is played by the person in the public life? And I'm also a little bit skeptic about how is it actually possible that Google does the balancing? Does it have enough information? Because if you look at the formula that is published, you have 1,000 characters to explain why you want certain information to be removed, which, if you require the remover of several links, is quite limited space in order to do so. I think my time is up. I would like to talk more, but maybe in the discussion. Thank you very much.
Thank you, Maja. And in this panel on judicial activism, we have a real judge also, and that is Marko Ilešic, who's a judge at the European Court of Justice, and who's our final speaker on the list. Marko, you have the floor.
Thank you. I enjoyed the discussion till now. In spite of the fact that I always wonder whether a judicial activism is something positive or negative. Professor Brkan tried to define this notion, something about broader interpretation or in this sense, but is it necessarily bad? I don't think so. Is it possible to make it otherwise? Of course, the Montesquieu's slogan is not applicable in all cases, and especially not in the cases where the European Union law should be interpreted. Because, of course, I am speaking a little bit from the point of view of the EU court in Luxembourg. It's not necessarily the same case for the national courts, because everybody knows, everybody is aware of the fact that the EU law is something which has no really systematic basis. There is an abundance of different sources of law, but without real basis, theoretical, in spite of the fact that the doctrine tries to find some general principles. Also the court does. So it is true that the court sometimes needs to interpret rules which are unclear, which are, as it's clear, often product of political compromises between member states, which are unclear, as the new president of the Commission said 2 weeks or 3 weeks ago in Luxembourg at the ceremony of installing the new Commission, that we are lucky, that the court is lucky that the rules of the European law are that unclear, because we have a lot of work about this. So it is true that sometimes we are inventive, but we should be. Let's have a look. The court was established in '52, that means 63 years ago, in the situation where the European law practically did not exist. Idea was, however, of the fathers or grandfathers of the treaties that there should be a court for the case necessary. The first president of the Court of Justice at that time of the European Steel and Coal Community, Massimo Pilotti, the Italian one, cited Dante Alighieri, who wrote in his work monarchia in Latin, ubi litigium esse potest, ibi judicium esse debet. That means where there is a possibility to have a litigation, there must be a court. And this is the theory of the equal powers of the European institutions. But as the European law is a very scarce one, the court is called to fill the gaps. As any court in this world, but here it is more accentuated. We, judges at the court in Luxembourg, we of course do not live in ivory tower, in an ivory tower. We look around. And as I said, I enjoy meetings like this today. And we listen to the doctrine, to national courts, to everybody. But sometimes we find out, and that will be my next and the only point which I'll try to discuss a little more in detail, we find out that sometimes our judgments are not well understood. And they sometimes, let's say, the world, the juridical world around us interprets our judgments in an activist way. I take the example of the Google Spain judgment. The judgment which I wrote. I was the judge rapporteur in this case, and every word in French, of course, was written by myself after a long discussion. So I know for every word why it stands where it is and why the expression is a certain expression is there where it is. There were other cases, but I really don't have time to mention them. There are two other cases in last year, in 2014. Okay, Google Spain is a judgment from May. We had Digital Rights Ireland and Kärntner Landesregierung case from April, where our court invalidated a directive of data retention, and there is quite a recent judgment from December, Rinaš, preliminary ruling reference from the Czech Supreme Administrative Court concerning camera recording and the data protection. But let me turn to the Google Spain case and what I think the imprecise comprehension of it. Yes, everybody is talking about the right to be forgotten. The court, as Professor Brkan mentioned, don't use this notion. Let's have a look to the judgment. Of course, it's mentioned when we speak about the allegation of parties, but in the part concerning motivation of the judgment, you won't find this word on purpose, because we didn't say anything in this judgment about the right to be forgotten. We balanced a little bit the human rights provisions in the Charter, Articles 7 and 8, the economic interests of data processing operators, but not really, we didn't say a word about a right of an individual to be forgotten, to demand that somebody erases data, his personal data. It may come in the future, but it's not in this case. I have to really read the expression used. I'm not entering into the problem of territorial applicability, which is, of course, a controversial one. But as to the right to be forgotten, I quote, the operator of a search engine is obliged to remove from the list of results displayed following a search, I underline 9, made on the basis of a person's name links to web pages. So what is the decision about? That a search engine operator, Google in that case, must remove the link, not the data. So we didn't say that Mr. Costeja González, in this case, the Spanish citizen, can demand that his personal data concerning a real estate auction 12 or 14 years ago should be removed from the newspaper pages, La Vanguardia, where it was published legally. But just to remove the link based on the research on the basis of name. So the decision is about agglomeration of data. You can't just put in the name of somebody and you get any information about it. But the information itself, it remains. It can be found by other means, not with this method of searching on the personal name. So I don't think that his judgment is that activist as it can be understood. But I understand the difficulties concerning understanding our judgments. We are 28 judges from 28 different countries. Okay, it was Grand Chamber in this case, so we were 15. We discuss the case in French. From 28 judges, there are 2 or 3 whose mother tongue is French. We all others, we learned it somehow. We speak some kind of French, but not really a brilliant one, I suppose. So we must look for the details with a lot of endeavors to try the good idea. Then the judgment is physically written in French. It's translated in 23 other languages, which is a difficult task. 2,000 people in the court do this job, but of course it can't be very translated very precisely. And I would like to stress that translating from French into English, it's very, very difficult. The sense, the idea of the expressed in the French language does not really meet the same aim when it is in English. So when, I'm going to conclude, of course, when we speak about judicial activism and data protection, the first things to do it's to try to understand very well the judgment. Perhaps the answer could be different afterwards. Thank you.
Thank you very much. Thank you to all the speakers. I will ask you to refrain a little bit from going to lunch immediately because we still have time for discussion, official time for discussion, I should say. The discussion will be introduced by Orla Lynksey from London School of Economics. So she will also moderate the debate.
Well, thank you, Bruno. Thanks to all the speakers. I'll keep this short as I'm sure there are questions from the floor. So I guess my first question was, we've had the directive for 20 years at this stage, and we've had remarkably little dialogue between the national courts and the Court of Justice in terms of preliminary references. And I was wondering whether the panel could maybe think or identify why that has been. So why have we had so few preliminary references in this area? And my first thought on that is perhaps it's because of the influential role of the Article 29 Working Party. And then the follow-on issue from that is whether this kind of soft law influence on data protection, so the role of the Article 29 Working Party, poses a greater problem from a separation of powers or from a legitimacy perspective than the role of a judge interpreting the rules of a very open textured directive, as we've heard today. And maybe now, I'll let you think about that for a few minutes, and we'll pass immediately to the floor for questions.
Hi, my name is Juraj Seifert, and I'm from the European Commission. And I have two questions for Dr. Brkan, actually. So you were speaking about privatizing balancing. In the Google Spain case, I heard another argument about this from BBC. They call it outsourcing the balancing. I was wondering how do you look at this from something that Mr. Eichenhofer mentioned earlier. That is the Drittwirkung doctrine, and which was adopted by the European Court of Human Rights amongst some other national constitutional courts, and where actually it is required from that eventually that it could happen that balancing is performed between the two private parties, and then the duty of or positive obligation of the state would then be to check whether this was performed properly or not. And on the lack of the adversarial procedure here, that's also another argument which I heard, that there should be sort of a right of the publisher at least to oppose or to submit comments or whatever to Google when he's deciding, where Google is deciding on the listing request. Here I again would like to draw a parallel with the sort of asymmetry which exists in some other fields of law, like equality, where in positive action cases there could be also asymmetry. And I was wondering whether the adverse effect actually on the data subject here would be much stronger if the publisher would be notified because of the Barbara Streisand effect, and whether the limited scope of the judgment, as explained by Judge Ilešic, actually means that the interest of the publisher in the listing is not so big that it should actually have a right to be part of that procedure compared to the interest, the very strong interest of the data subject.
Thank you for that question. Maybe one last question here from Joris.
Yeah, so I was expecting to hear a little bit more about what would be driving the judicial activism. If you think about judicial activism, you think there must be some kind of politics or ideology of a court that is driving this. And I would like to suggest that maybe in the case of data protection, that doesn't necessarily have to be some ideology or political program of a court on data protection itself. And I think in particular at the Court of Justice level, it could have to do with other political programs dealing with competency and settling of competency at the EU level on issues that they have not necessarily ruled on before, and filling the gaps that maybe exist from a European law perspective. So I was wondering maybe some on the panel could say a little bit more of that, of what they see of political programs of the court and what they think, looking at the Court of Justice of the EU, could be the political program when they are activists.
Thank you. So maybe one last question, and then I'll pass to the panel for their concluding remarks.
Thanks a lot. Roberto Lattanzi, Italian Data Protection Authority. I would like to ask to the Judge Ilešic if it's possible to build a bit on one part of the decision in Google Spain case, and exactly there is a passage in the decision where it said that in principle economic interests or rights are not prevailing against fundamental rights. And this is a very important assertion within the decision about the balancing exercise, and it seems to be, and in despite of it, it seems to be a sort of obiter within the decision. If you can build a bit about this very important point, I will be very, very glad. Thanks a lot.
Thank you. Well, perhaps we could start with Gloria and move down the table for some concluding comments.
Yes, so I will just try to answer to your question. So we had a limited number of questions to the Luxembourg. Why is it? I'm not sure it's linked to the success of the Article 29 Working Party. I think it's more linked to the failure of this harmonizing strength of the directive. We know we need a regulation because the directive did not harmonize the single market, and it's in the political interest also of member states not to have this full harmonization. If they can have still the freedom to decide what they want to decide, I think they have been using that freedom. On the question of political programs, I think Spain is an interesting example because I mentioned this judgment where there was a question of unconstitutionality of some of the provisions of the Spanish data protection law. It was interesting because actually before this judgment there was we had another law, and some of its provisions related to the transfer of data between public administrations. It was approved by the government, and the party in the opposition thought this was contrary to the fundamental right to data protection, this transfer, uncontrolled transfer between public authorities. So they followed the ombudsman and introduced with the ombudsman a complaint against the Constitutional Court. The Constitutional Court thought about this a long time, so in the meantime, the governments changed. And the new government, which was before in the opposition, introduced a new law with the same questionable parts about public administration powers to transfer data. So they went to the Constitutional Court and said, remember that challenge that we introduced, please forget about it. Now we think it's constitutional, because now we are in the government. And the Constitutional Court, well, you cannot really say, do this now, sorry that the question was introduced. And then we had this judgment. So I think it's political, yes, but not always very consistently political.
Shall we keep the same order?
Yeah. Shall I?
Oh yeah, sure.
Okay.
I thought it was going to go down the... Oh, yeah. Yeah, so I would only address the two questions. I will not go into other more general issues. On the Drittwirkung, that is a very good point that you raise. However, I wouldn't say that they are completely the same, because the Drittwirkung is about the question between whom you apply fundamental rights, and the outsourcing or privatization of balancing is about by whom is the balancing being performed. You can claim that the outsourcing or privatization is the consequence of Drittwirkung, but it's not always the case, because a public authority can very well also balance the rights that apply between two private parties. But I think it is a very important and a very strong link. As to the lack of adversarial procedure, I wouldn't necessarily agree. I think in the particular case of Google Spain, maybe the newspaper didn't have interest, but another newspaper or another company might very well have a very strong interest that this information is being published, especially if you think about a newspaper that reveals something important about a public figure, and then this public figure, after 10 years, wants this link to be removed, but he is still a public figure, and the corruption scandal in which he was involved is still very hotly debated. So, you know, I think it really depends on the case, or if you have a company that has an economic interest and that wants to advertise something, in that case, I think also the company doesn't want anything to be removed from the website that would diminish its economic power. So I would really say it depends on the case, and that's particularly the flaw of this outsourcing of balancing. If you have a public authority will probably hear both parties, whereas a private party would probably not do that. That's why I find it very, very problematic. Yeah.
No, so I would like to follow on this point. It seems to me that why is the search engine is in first line? And I think because this kind of very limited outcome, that is limiting only the indexing of that particular individual, can only be achieved by the search engine. The private party, the publisher cannot do that. Either you take it out or you let it in. There is no other choice for the private party. And this, I think, raises the issue of it would have been possible, obviously, to have, in any case, a decision by a public authority, that is, the search engine, rather than deciding by itself, sends forward the application to a public authority, or go direct to the public authority, and then a decision is taken at that level. There are problems also in this solution. I also agree, on the other hand, with what was just said by Maja, in the sense that I cannot see a problem in the search engine informing the publisher that there has been this request, putting a short time for giving an answer, and then making a decision by using the information provided by both parties. I think that we may also consider that also the publisher should be entitled to challenge the choice of the search engine to the Data Protection Authority. Why not? It's a data protection issue. I don't, while I think that there may be some rationale for having the search engine to decide on the matter, I don't see why to exclude the publisher from that. Final point, we must consider also, you said that the balancing should be done by the actor himself, by the search engine. But the issue that we need to consider also is what is the outcome of a failed balance? Is there going to be a sanction? Is there going to be a compensation? What kind of behavior is this going to induce? This is why I would, I don't know, but the thing will go on, but maybe the discipline of the e-commerce exceptions would be, from liability, would be something to be considered in this regard. But I stop here on this point. Sorry.
Okay. So, yeah, okay. Before I give you the last word, maybe, or just you, that might be more. I just would like to answer your question, or try to answer your question you made. Why is there so little preliminary references so far? From the German Constitutional Court, they have never made use of that possibility of 267 TFEU, or at least in the area of data protection and privacy. And, well, I can only assume, you know, there is kind of it's maybe a hidden agenda of that maybe also relates to the question Juris put up. So what are the reasons for that? I can only assume. I think the Bundesverfassungsgericht for a long time had the idea that they are providing a higher level of fundamental rights. There has been than the European Court of Justice. There has been in the 80s and 90s, whenever there was a new development on the EU level, for example, the Maastricht Treaty and so on, they have come up with decisions saying, the as-long decisions they are called. As long as there is not an equivalent standard of human rights on the EU level, the German Constitutional Court needs to, or still wants to, have the control to decide over the implementation of EU law. So that's kind of a rather strict and activist approach, right? And so there is the saying, over the Federal Constitutional Court, or above it, there is only the blue sky. And now the blue sky seems to turn blue and yellow, with yellow European stars, I guess, since just recently it has been not in the field of data protection, but in the field of the European central banks and their competence. Is the first time that Germany has made use of that possibility of preliminary references. And we can look forward how that will develop, especially in terms of the European data data protection regulation. I think as soon as the competence of the EU law is widening, of course the competence of the ECJ is widening, and that also has to be respected by Karlsruhe, the federal. So I think.
Just two short points. First, the concrete answer to the comment on the economic interests of Google in this case. Yes, you're obviously referring to the paragraph 81 of the judgment, where the court said, in the light of potential seriousness of that interference, it's clear that it cannot be justified by merely the economic interests which the operator and so on. So yes, you're right, it's an obiter, but it's a part of the said balancing between different interests. And this is practically an answer to the allegation of Google Spain, or Google, that both interests, privacy, data protection, and economic interests of the search engine operator must be equally appreciated. We, of course, we didn't agree with this. Here, the data protection interest or the protection of to keep privacy prevails. And a more broader answer concerning also other questions. We must be aware of the fact that in the preliminary ruling procedures, the court faces two problems, or the judgment must have two objectives. Firstly, to help the national court, who introduced the reference, that this court, this very court, could resolve the litigation in his case. In this case, our response, our judgment must help the Audiencia Nacional to resolve the case, which he must decide. But don't forget, all judgments of our court has an effect erga omnes. So the formulations are sometimes broader, much broader than it should be necessary for the asking court, because this judgment will affect any litigation before any court in the European Union. And as you may have read 2 weeks ago or some weeks ago, a French court, the Tribunal de Grande Instance de Paris, decided in a case which never reached, probably never will reach our court, but they respected the ruling and they imposed a newspaper to remove certain from the list on which you receive when you search by the name of the person, to remove this link towards an information which affected a criminal case which this person had 10 years ago. So there is a double effect of judgments of this court.
Okay, so that brings us to the end of this panel. So thank you very much to the speakers. The data protection is on the move, as we see from the overall theme of this conference. Judicial activism is then therefore also on the move, not so much the concept itself, but of course the fact that judges are being asked to confront themselves with this data protection on the move. There are new issues, new challenges, and each time judges also have to reflect what is their role, what is their proper role in this field, as opposed to the role of regulators or of private actors. So thank you to the speakers to have helped us in thinking about this topic. And bon appétit.